Good afternoon, Michael from Owens Castley Real Estate. We're really lucky to have Jeremy Coleshaw from Coleshaw Miller Lawyers. Jeremy specialises in family law, and there's the old saying, death, taxes and divorce is also a big part of our work. So rather than beat around the bush, I thought it'd be a really great opportunity to join with Jeremy and get a better understanding how family law works and how people should engage depending on what level of the process they're going down. And we just thought we'd have a chat about that. So thanks, Jeremy.
Thank you, Michael.
If someone's considering or in the middle of a marriage breakup, when should they really engage with you and what can they expect? How does this process work?
Look, I think I would advise anyone who's going through a relationship breakdown to firstly attempt with their partner to reach some sort of agreement or resolution as to, and we're talking about financial settlements here, we won't deal with children in this category, in relation to at least identifying what their net assets are. Net assets is simply a formula that we use to calculate assets less liabilities. We also include superannuation in that. And obviously one of the largest assets that may arise from a property settlement is the matrimonial home and or investment properties that they may both own.
And in that scenario, would they speak to their accountant first, or do they engage you and then you then work with the accountant, or is this something that your firm handles in its entirety?
Look, if people do have accountants, we find that it's useful to be able to engage with those accountants, particularly in circumstances whereby there may be family businesses involved or more complex structures, say involving family trusts, family companies, unit trusts. So it really depends on the circumstances.
Okay. And when do you suggest that they do engage you? Is it, does one part engage you, or is it two, or how does that work?
Well, we can only act for one partner, and in that respect, what I would recommend is we will often have a preliminary chat and a first consultation, as we would call it. And in that interview, we go through the basics. We will receive instructions from the client and they'll set out their financial position. The other issues that we look at are length of marriage, the assets that have been brought in at the commencement of the relationship, assets that have come in during the relationship. And during that first consultation, we're in a position to make an assessment as to what a likely range of outcome will be. It's important to understand, Michael, that in those circumstances that family law is a very discretionary system. That means that the judges, and we're not talking about matters all going to the family court, but when we give you advice, there are ranges within which a settlement may occur. In addition to that, with the advent of financial agreements, we're now in a position to, and we describe it as reverse engineering settlements, whereby whilst they might not strictly fall into accepted family law ranges, we're able to do settlements whereby the parties can reach a resolution that suits their ongoing circumstances, particularly if there are younger children involved. Parties may wish to stay in the matrimonial home for a longer period of time after the separation, so we're able to engineer those structures for those.
So it's almost like a tailored solution as such.
Correct.
And in your experience, not to use, Owens Castley is all about doing world best practice. If you had to say to someone, the best outcome that we see for everyone involved in a sad situation, how does that look? What should people be doing or planning?
Well, from my perspective, the best outcome for a client would probably be to use us as little as possible. Lawyers aren't cheap. The legal profession isn't cheap. Engaging in family court litigation is not cheap for the simple reason that there are hoops that we need to jump through, which all cost money. You may need to involve forensic accountants, you may need to involve barristers, all of that adds up.
So potentially are you saying that someone could do that, could a couple do it themselves?
With appropriate guidance and depending on the complexity of the matter, the answer is yes. Where the pitfalls arise, even if there's agreement, is whereby there may be issues such as taxes, particularly capital gains taxes. We may have scenarios whereby real estate is owned by family trusts. Real estate may be sold, thereby incurring a capital gain or a capital gains tax, and we have to make sure that we get appropriate advice from experts, which are accountants or financial planners in relation to that. So what I'm advocating is that, and I'm a big believer in mediation. I'm a big believer in using mediators, or they're also known as family dispute resolution practitioners. Again, depending on the complexity of the matter, the lawyers don't need to attend that. They can be at the forefront to provide initial guidance. The parties can then sit through a mediation, and then we can document the agreement and have those orders made in the family court.
So if someone is in this scenario, the next step would be to contact you or someone within your organisation and say, look, this is where we're at, and then you'll give them a backwards path as such to work out where they're at to get to the best resolution.
Certainly, and what's often not highlighted is that we will see clients who there is an element of uncertainty about the status of their relationship in their marriage. One of the first tick boxes, insofar as we're concerned, is I have a duty actually under the Family Law Act to ascertain that those parties have gone for appropriate counselling to see that if the marriage is in some difficulty, whereby there can't be any reconciliation in that respect, and then if it's obvious to all concerned that the relationship has broken down, we give them that preliminary advice. And some of that advice may well be to do nothing, or we may give them advice in relation to taking certain steps. And we do a lot of consulting now. In other words, that we allow the client to act on their own behalf with us in the background, assisting them in that respect.
Right, okay. So next step from here, if someone's contemplating, give you a call, and hopefully you can...
Yes.
As you say, you can't do anything about the past, you can only control the future. And I think that's the reality of what we're dealing with today. My dealings with Jeremy today, in the past as a friend, has been, he's a man of absolute integrity, and he's demystified a lot of this. I know that Angela's the luckiest woman in the world, and we're 25 years married, and hopefully I won't use his or Simon Berry's business, but it is part of today's modern world. So I'll put notes down below this video on how to get in contact with Jeremy, or if there's anything you need to clear your mind out, I'm sure he'd welcome your call. Thanks, Jeremy.
Thank you very much, Michael.
Good on you.